And again, thank you for joining us for this week's AOZ Talk series. Today, we are very fortunate to have VeeCee Spears. I keep calling you Spears and it's Spears, so I apologize.
It's okay.
And we have Keith Leuty as well. And they're going to be helping us learn a little bit more about Medicaid and those 5 important documents, legal documents that we're going to be needing. I think it's a good conversation to have. They're going to talk to us a little bit about that, and then we can ask some questions. Again, this is going to be recorded, so that way, if there's anything that you want to touch back up with or you want to share with your family, this is a great opportunity to do so. And you'll have an opportunity at the end to ask questions as well. So we want to give plenty of time for that. So let me first introduce our speakers for today. As I mentioned, Keith Leuty is an elder attorney. He did graduate from St. Mary's Law School, and he has been with their firm since 2014. Is that correct?
Correct.
And he focuses on wills, estate planning. He assists military veterans with planning and receiving eligibility to receive that aid and attendance benefits. Small fact also, when I was doing my research, I didn't know you also have a PhD in clinical counseling too. So you have a great counsel, literally a great counsel, a great counselor. So I'm glad that you are here to provide great wealth of knowledge. And VeeCee as well she works again at Barnett Leuty Law Firm, and she has an extensive experience and knowledge regarding Medicaid, regarding long-term planning. I call VeeCee like my go-to girl. If someone has questions by that, I know that VeeCee will be able to help families as best as possible. If there's a question, I can reach out to VeeCee, and she has, again, over 20 years of experience, and she brings that and shares her knowledge with all of us. She also is a group facilitator for a group that meets here in Austin. It's the Linked Network, and that's where we can gather and partners with different agencies, and we can learn what's going on and how we can best serve our community. VeeCee, have you been doing that for 9 years or so?
Yes, I've had the group actually almost 10 years now.
10 years. Yes, just great work that VeeCee has committed to the Austin area and to the Central Texas community. So she is a wealth of knowledge, a great resource to have. So I appreciate you all being part of this conversation with us and helping us out.
Thank you. I'm glad to be here.
Our pleasure.
And we talked a little bit about having Keith start off with talking about those 5 documents. And a lot of times we're wondering what those 5 legal documents are, right? What is those must-haves? So that might be a great place to get started with our questions. Keith, can you talk to us a little bit more about that?
Sure. Thank you, Shannon. Hope everybody can hear me okay. Still getting used to this Zoom thing. I know when we do in-person presentations, they say speak to the person in the back of the room. And so you know how to modulate your voice. And it's a little different sitting in here in a quiet room. I hope I'm not too loud or anything. But so yeah, we get a lot of people into our office and they say, look, I want to plan for the future, but I don't know what I need. And so what we tell people is there are 5 critical documents that everybody needs. Now there's some other ones that you can get if you want to achieve certain objectives, but the 5 basic ones that we tell people start off, of course, with a last will and testament. And most people, when we say a last will and testament, they're familiar with that. They know what it does. But what's crucial about having a will in place is that when you die, if you don't have a will in place, the government has one for you. There are laws that deal with if a person dies without a will. It's called dying intestate is the word that they use. And there are laws that deal with if you die intestate, here's how your property is going to be divided. And that's not always what people want. So if you have a will that clarifies how you want your property divided, who you want to be in charge of making sure that it's divided properly, questions like that, then that's what's addressed in a will. The second document that we tell people that you need it's called a statutory durable power of attorney. Some people refer to it as a financial power of attorney as well. And what that does while you're living, it allows you to name who you want to be in charge of your money in the event that you were in some type of a condition where you no longer manage your own money. Sometimes that's by choice. We have clients who come in who say, look, my daughter or my son, they're paying the bills and handling all that for me now. Other people, it's more a matter of they just don't have the energy for it. And in some cases, we have people who've been diagnosed with some type of cognitive impairment like dementia or Alzheimer's. And so the doctors are telling them, you need to get this signed while you're still clear-headed enough to legally do it. So that's it's called a statutory durable power of attorney. Kind of cousin to that is something called a medical power of attorney. That is a separate document that allows you to designate who you want making your medical decisions for you in the event that you're ever unable to do so, whether temporarily or permanently. So the medical power of attorney and the durable power of attorney work hand in hand, because they deal with both your property and your health. So the reason that I kind of talk about those two at the same time is because there is a consequence, and it's not a good consequence, if you don't have those two documents in place while you're living. And that is, if somebody were to, let's say, have a stroke or some type of a very significant health event where they went from healthy, one day to not the next, and they couldn't manage their affairs, the only other legal recourse out there would be to seek a guardianship. And guardianship is a very big deal. It takes a long time to get through the courts. It involves not only your guardianship attorney, but also what's called an ad litem attorney that's appointed by the court. It involves multiple court hearings. It can take a year and a half sometimes to finalize all of that. And then, of course, you're paying your attorney all this time. Guardianships are considered to be fairly expensive. I'm not a guardianship attorney, but I've talked to guardianship attorneys that I know, and they said, you're probably looking at $12,000, $15,000, somewhere in that range to do a guardianship. And then after you get the guardianship, if you want to manage that person's finances or their health, you have to make an appointment with the court and go see the judge, tell the judge what you want to do, get your attorney, of course, there, and you're paying your attorney's fees and all that. So it kind of becomes this lifelong, as long as the person is living with a guardianship, of going back to court over and over and over again. So if you have the durable power of attorney and the medical power of attorney in place, it is 99% certain you'll never have to seek guardianship. Nothing in law is ever 100%, but 99% sure. So the fourth document that we tell people that they need to have goes by several different names. Some people have heard it called a living will. I don't personally prefer that term, because when you say a living will, people will get it confused with the last will and testament. Instead, we call it a physician's directive document. And the physician's directive is a document that lets you put down officially and in writing what your choice would be if you were ever being kept alive on life support by machines. Because if that scenario ever arrived, the doctor would walk out into the waiting room to speak to your loved ones. And we don't want to have a scenario where the doctor says, so what does the family want? Because the family on the left side of the room might say, pull the plug. And the family on the right side of the room might say, leave it plugged in. And the people in the back say, I don't want to be involved and have that on my decision list. So this is a document that lets you be the one to choose if, when, and how that scenario ever developed. What is it that you want? Because ultimately, it's your life, and it should be your legal decision. And you don't want to put your family in a situation where they have to make that decision. So that's the fourth document. The fifth document is called a disposition of remains. And this deals with after you've died, after you passed on, what do you want to have happen to your body? It's not a conversation that comes up over the dinner table much. And so you don't want to pass on and then suddenly have your loved one say, I have no idea what mom or dad here would want. We didn't talk about it. So that's a legal document that, one, appoints who you want to be legally in charge of your body so that there's no mistake who's calling the shots. And then second of all, you put on there what your wishes are. And that can include obvious things like, do you want to be buried or do you want to be cremated? Do you want to have your organs donated? It can also include things like, well, what about your funeral service or memorial service? Some people want them, some people don't. If you have a service, do you want flowers? Do you want music? You can be as specific as you want to with this document. So, so two of these documents deal with after you're dead, your will and your disposition of remains. Two of the documents deal with, when your health begins to fail, but you're still living. That's your two types of powers of attorney. And then there's the physician's directive, which is essentially you're being kept alive by machines. So if you have those 5 documents done, you're pretty well covered for most things that would come up. Like I said, there's some other documents that we do for people from time to time, depending upon their specific situation. But those are the 5 that we tell people. And we at our office, because we want to encourage people to get all of the documents that they need, we kind of bundle them up in a, like what they call it, a happy meal of legal documents, so that we encourage people to get all of the documents that they need. So as long as I have a few minutes here extra, because I know VeeCee's got to talk about Medicaid, so I've got to watch my clock. I also want to mention a couple of other documents that are a little bit next level beyond the original 5. And the idea with the will, to do a probate here in Central Texas is not that bad. You hear stories from other states about probate being really expensive, taking a long time. That's not the case. Here in Travis, Williamson counties, probate process is fairly straightforward if you have a good will, and the time frame is in the range between 3 and 4 months usually. Now with COVID-19 and the courts being shut down, obviously that changed the rules temporarily, but normally it's about a 3 or 4 month process. And so there's nothing wrong with doing probate, but some people want to avoid probate if they can, if for no other reason than they want to have something passed to a loved one sooner than 3 or 4 months, not waiting on probate. They may not want to, probate is a public event. People can go online and pull up the legal documents and find out things. So if you want to avoid that, one of the documents that nobody's ever heard of, and I usually, when I'm in a room full of people and I can have everybody raise their hand and show me, I'll say, who in this audience has ever heard of something called a ladybird deed? And occasionally we get a hand that'll raise, but it's not really common. And ladybird deeds are one of my favorite documents because there's 2 reasons that I bring them up. One, a ladybird deed allows you to transfer ownership of real estate to somebody of your choosing outside of the probate process. So many times we will have people come into our office for help, and we ask them about their assets, and they say, well, I've got my house and I've got whatever's in their bank account or their investments, but that's really it. There's nothing out of what we would consider out of the ordinary. And so they're hoping, even though they have a will, once they get it in place, that's just a safety net, that they can actually transfer those assets without having to go through probate and wait and pay legal fees and everything. So the way that you transfer real estate outside of the probate process is with something called a ladybird deed. About 5 years ago, the Texas legislature also created a sister to the Lady Bird deed. They call it a transfer on death deed. They're essentially the same thing. Lady Bird deeds came up through the court system. Somebody made a Lady Bird deed one time. It had to go through the courts to see if it would stand up. And but it's been around since about the 1970s. So the way a Lady Bird deed works is you have it drafted and then you go file it in the county where this real estate is. And it remains there on file. And when you die, one of your loved ones will take your death certificate down to the county clerk's office, say, hi, we have a Lady Bird deed on file. They'll check it. And as soon as they have confirmed that, they will go into their computer and change the ownership right then and there without the need for anybody going to court or waiting or doing probate. The other part about a Lady Bird deed that is so crucial, and this is a good segue to what VeeCee is going to be talking about with Medicaid. In the Medicaid process, Medicaid will tell you that it is okay to own a home and get on Medicaid. That's fine. Your home is an exempt asset. Medicaid has asset requirements, and I'll let VeeCee talk about all of that. But Medicaid will tell you that it's okay to have a home and get on Medicaid. What's kind of buried in the fine print is that if you own a home and you get on Medicaid, and then you're on Medicaid for however many years, and then you pass away and they go to probate your estate, to probate your will, Medicaid will show up at court with a list of everything that they paid for you while you were on Medicaid. And they will put a lien against that real estate for that amount, and they will get it. It's really, really hard to fight at that point. However, a Lady Bird deed defeats all of that. A Lady Bird deed removes the real estate from your estate long before you would ever get to court. So Medicaid has nothing to attach their lien to. So anytime somebody comes to us and they're talking about, hey, I need myself or my loved one needs to get onto Medicaid, one of our first questions is, do you own real estate? Do you have a house? And if so, we want to make sure to make the necessary arrangements so that upon your death, your house is not sitting there for Medicaid to go put a lien against. There was a friend of our family who came and told me a story, something that happened in her family. She had a relative who this exact scenario happened, and the lady who passed away had a house that was worth $325,000, I think it was, and she had intended for, upon her death, for this house to be sold and for the money to be split between her two sons. So, you know, the math on that is, you know, it's over $150,000, $160,000 that each of the sons was supposed to get. Because they didn't know about Lady Bird deeds, Medicaid came in and put a lien against the house for $140,000. So this $325,000 house that she thought she was leaving to her two sons was now subtract $140,000 from that. So her sons got significantly less out of that. And all of that could have been defeated and avoided if she would have known about Lady Bird deeds. So that's, I stretched it. I'm supposed to talk about the 5 documents everybody needs. Not everybody needs a Lady Bird deed, but it's such a wonderful document that when I have time, I like to throw it in there because most times people don't know what they don't know. And the more we can tell people, the more we can help them. So since I've kind of segued into Medicaid, VeeCee, as Shannon was saying at the beginning, VeeCee is our resident Medicaid expert. She worked for Medicaid for over 20 years and helped write a lot of the laws, helped craft them and draft them. Medicaid rules and regulations are a different world that most of us know nothing about. And so there's just nobody that I know of who's better at speaking to Medicaid than VeeCee. So VeeCee, I'm going to pass it over to you and let you talk about Medicaid.
Okay, very well. I hope let's see, I'm not muted, okay? I I did work in Medicaid, and I tell everyone I loved every day I worked there because I got to help so many families to get the care they needed for their family members. But it is incredibly difficult to understand the many rules and regulations of the state Medicaid program. And it's primarily just for when your family member needs to be in 24-hour care. And that has to be established that you have a medical need for that before that program is available to you. And you have to meet what they call a medical necessity. You can't use the nursing facility for a retirement home. You have to have a medical need to be there. And there's lots of different regulations that go along with it. We have to come within a specific income basis, as well as typically an individual can have only $2,000 in total resources. And we can, like we say, we can exempt your homestead on an individual. We have a cap on that of $595,000 value. But if you are a married couple and you own the home, and one of you enters the facility and the other one remains in the community, there is no cap on the value. So that's something that is a big plus too, and that people need to know, be aware of. Otherwise, if you're an individual, that $2,000, that includes everything. That includes money in the bank, any kind of investments, any kind of property. And that property is also mineral rights and those types of things. Anything has a value, and we have to establish that value at that time. You are allowed to have one vehicle. It doesn't matter what kind or what the value, but the second one, if you have two, then the second one starts cutting into your $2,000 maximum. And like I say, we have different policy for married couples when one needs care. And I'll talk to that a little bit later. Our policy is made such that there is a cap on income. And the income cap is $2,349 a month. That's the maximum you can make to meet the requirements. However, there's always ways to get around that, because the average cost of care in the state of Texas is $6,500 a month. If you make $2,350, you still don't have enough money to pay for your care. So there are still ways within the policy that we can set up your income such that we can still qualify you if you make more than the $2,349. And don't ever think that what somebody tells you is policy. Always call me. I talk to everybody. I give you my cell phone number. I talk to everybody, and I give you the information that's correct and that you need to know about all of this. Don't listen to somebody, because every state has different policy. Somebody may have done the Medicaid program in another state, and it's not the same. Every state has adapts their own Medicaid policy, and it's all taken from the federal guidelines. So all you have to do is ask. All you have to do is ask me, if it's something I don't happen to know, which is pretty rare, I'll look it up for you and get back with you on that. But keep in mind that if you're needing to have 24-hour care because you've had some kind of medical event, and maybe you have $200,000, don't think that you have to spend all that before you can meet the qualifications. There are also policy allows for gifting and or transfers. If you opt to set up a trust and you need to want to transfer money into that trust, then there will be some penalties, which means once you're below $2,000, we can still get you on Medicaid, but there will be some penalties that you have to pay your daily rate. So we can establish that. We can many times, we can always usually save at least 60% of the total assets, and many times a greater amount than that. So don't ever think that you have to spend it all, because I never talked to anyone that worked their entire life that didn't say, I want to leave something for my family members. I've worked hard. I don't want to give it all to the state of Texas. And I agree with that. Many times people didn't take good care of their money and they blew it all on whatever. Maybe they wanted to, go to Las Vegas and gamble. Well, if they can get Medicaid, even though they didn't take good care of their money, why can't we help people to be able to gift the money that they did take good care of and provide that for their family members? And we know exactly how to walk you through that. I will take you all the way through that and you won't have to worry about it. Like I say, it's very complicated, but when we sit down and start looking at your numbers, everybody's different. So we would structure something for your individual situation. And you will be able to know exactly what we're doing, and we will listen to you in what you want to do about passing on your assets to your family members. And that's exactly what we will construct for you. And also, as Keith mentioned to you, the Medicaid Estate Recovery Program it's a federal guideline that all states have to adhere to be able to get federal funding. Federal funding is very important. The state pays 40% of the Medicaid bill. The feds pay 60%. So it's incredibly important for us to participate in the Medicaid Estate Recovery Program, and that's where you do the Ladybird deed, because that keeps our state budget intact, because it's an expensive Medicaid program, and many times our family members that live in nursing facilities live many years. They do very well when they get there, and the care is very superb. When I first started working in Medicaid, the average stay was like 3 months. And now I have people that are in the facilities 5 and 6 years. So it enables them to have the care that they need to live out their life. And they just amaze me all the time at how creative and caring they are of the residents that are living there. Because I'm in and out of the nursing facilities until they've blocked me. I'm usually in and out of them all the time. More so in the central to North Austin area, on up into Round Rock and out Cedar Park, and on up to Georgetown are my regular stops. Now I go to the south ones as well, and down to Buda, and they're just amazing. They're just amazing. People talk like they're prison sentence, but I think you'll be wise when they open up again to take part and go there and see the loving, caring people that are there caring for your family members. Also, I was going to touch a little bit on our spousal impoverishment, is what the state of Texas calls it, when you have a married couple and when one of the couple goes into a nursing facility and the other one remains either in the home or they can live in assisted living if they don't have to have, if they're being billed for rent. Anywhere where they pay rent, they can still be considered a community spouse. And there are ways for us to actually save all the assets for the spouse that remains at home. We don't have to spend down. We sometimes have to use some financial annuities that we use for transferring the spend down. We do a spend down on an annuity that's a short term. Most of the time we do 2 months annuities. So if we'll just give a ballpark on this. So if you had 200,000, and the way the state looks at it, they say half is for the spouse that stays at home and half is for the spouse that's in the facility. So what we would do is take the 100,000 for the spouse that lives in the nursing facility, and we would purchase an annuity with that. And we would have some expense at purchasing the annuity, but we would give you 50,000 back the first month and then the other 50,000 the second month, so that you have spent down your required assets, but we actually gift them to the community spouse. And that's what policy allows. So it's a very good way to preserve the assets for the spouse that isn't in the nursing facility to still have the means to live independently. And we utilize that policy a lot. And we have another associate that helps with the financial aspects of that. I don't sell annuities. I don't think that looks like a conflict of interest if I was going to profit from making selling you an annuity. So we have another associate that actually is in that type of financial business. He has his own financial company, and he works diligently with us in helping you with getting your assets, either purchasing the annuity or spending them down, or however we need to be able to conserve your assets. And he's great with that. And we work with him and have for the last 4 years. We've all been working together as a team, and we're just, I must say, we're an amazing team. We all are very helpful to fill our roles, because I don't speak to legal and I can't speak to financial, but I can tell you the rules from front to back. And so that enables everybody to do their job very high functioning. And, but the spousal impoverishment, you know, it doesn't matter if you have millions of dollars. We talk to families many times that there's maybe their ages are there's a large grant there in between the ages of the spouses, and maybe one is quite a bit older and in very poor health, and maybe the younger one is maybe 60 and has maybe a lot of years left to live. So we need to save all the assets that we can to provide the care that the 60-year-old needs, as well as being able to cover the 24-hour care that the older one needs. And but we can explain all of that. We have families that maybe they're the same age and one has better health than the other. I just lost my mom last year, and she was 3 months shy of 100. And I never, ever thought my mom would live to be 100. And she nearly did. But, you know, when you think about what people have gone through and all the, you know, the types of work, and my dad worked in asbestos many years ago every day, and he ended up with some serious lung issues, but he still lived to be 93. And so, you know, we still want them to be well cared for 24 hours a day. So what we like to do is to look at each particular situation, and we design a plan for you that we can help you to have the ability to get the kind of care that your family member needs, and make it as easy as we can. We will help you to understand what we're doing at all times, and at all times, everything will totally follow policy for the state of Texas. I worked in that department, so I'm very familiar with it. And that's the only way we work at our office, is we're going to do the best job we can, and we're going to follow the law and follow the rules, and we're going to do it as easily for you as we can.
Thank you.
So before we open it up for questions, because I'm sure many of you probably have some questions, I just wanted to kind of echo what VeeCee was saying there at the end, that we do tailor every plan to each individual person's needs when they come in. I don't charge to meet with people, because I want people to feel free to get information and then process that information. And if you have follow-up questions, and not be worried about, oh, are we being charged just to learn about this? So we're happy to meet with anybody, either in person or on Zoom or over the phone sometimes, whatever it is, to try to assess your situation and tell you what's available out there. You know, and we'll make recommendations as far as what we think might be best for your situation. But the overall goal is to not be one of these people who was uninformed. We've talked to enough people over the years who said, oh, if I only would have known, I would have done it differently. You know, they wind up, they sell their house, they move into assisted living, and then all of the money that they got from the house is what they wind up paying the assisted living. So they're watching their life savings just go down, 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 when there were other options, if you know who to talk to and find out. So I'm not sure, Shannon, how you do questions on Zoom, if you leave it to, if, you know, since you can see everybody, if people are supposed to buzz in with some button, or if somebody just wants to raise their hand and then shoot them, however you want. We'll answer any questions you guys have.
Sure. So everybody has the ability to unmute. I know Ed has a question. Jackie had asked a question over the chat. Jackie, her question was to ask if would a wife still have to go to guardianship court to get guardianship?
Oh, great question. Yes, actually, we frequently will get that question where people believe that, well, this is my spouse we're talking about, and so legally I have the right to do everything for them, and that's just not true. Not at all. Absolutely, spouse would have to, if you wanted to, dot the I's and cross the T's. Now, let me kind of have a qualifier to that. If it is a question of, I need guardianship so that I can talk to my spouse's doctor, and you happen to have a doctor who you guys have used for a long time, and the doctor says, oh, I'm willing to waive that, that's okay, I know you, then you didn't need guardianship for that after all. Also, when it comes to spouses, most of the time their money is commingled. You know, community property state, half is owned by each spouse. So if you're both on the bank account, do you have to go get guardianship to move money where you're listed as a co-owner? No. So there are exceptions, but when I answer that question, I have to do it from the attorney perspective of, okay, under every scenario you want to be covered, dot all I's and cross all T's. Yes, a spouse could actually be required to have guardianship. Absolutely.
Thank you, Keith. Ed, do you want to ask your question?
Thank you. This is for VeeCee. Between the levels of nursing home and fully independent living, what, if anything, does Medicaid offer for someone who has dementia, who has no assets, who otherwise qualifies for Medicaid, but isn't far enough along to necessarily be in a full-blown nursing home? What, if anything, is available for that person?
Okay, that is a question. I don't make the medical decision whether or not they meet the qualifications. Typically, you can take the medical records to the facility, the nursing facility, and they can tell you whether or not they meet the medical requirements. Now, in some areas, Medicaid does have a few assisted living communities that they make a waiver program for. I worked many years up in the Dallas-Fort Worth area, and we had a lot of participants back then. And we had actually one community here that did take the waiver program and had 22 beds where they could live in assisted living but still get Medicaid assistance for that. Well, after that community sold, we don't have any that I know of here in this area. Now, there are some in other areas that will do the waiver program, but you typically have to get on a waiting list for that type of program where they're not in skilled nursing yet, but they still need to have care. And sometimes those waiting lists become quite lengthy. So, you know, it's like, I talked to someone this week that she said, well, she'd applied for Medicaid and they couldn't get her family member on Medicaid. Well, come to find out, they weren't in a nursing facility. And they have to already be there and meet all the requirements to qualify for that. And even if they're wanting to go to the assisted living or the waiver program, it's almost easier for them to go to the nursing facility first, meet the medical requirements for that because they're ideally the same, get on the Medicaid program, and then they can transition to an assisted living community, or actually they can go back to their home, but it's not 24-hour care when they're in their home. So there are some other options. They may not be available in every case for everyone, but there are some other options there.
Thank you,
Thank you.
VeeCee.
Uh-huh.
And I think that's a really good question that brought up, because that's oftentimes one that we do often get to, is how can one do that when you do have a undiagnosis, but you do have the symptoms of dementia that we see. So thank you for helping answering that. Donna also has a question.
Okay.
Okay. I'm sorry, I could barely hear. Is it my turn?
Yeah, it's your turn.
Okay. Okay. And I'm not sure who. My husband is the person that has Alzheimer. Well, he doesn't have Alzheimer's. They're calling it progressive dementia. And we did a simple will in December. So my question is that what he wants to redo parts of the will because of certain family members' reactions to our situation. At what point is he not competent to redo a will?
Okay.
He's declined some. I mean, he's alert, but he's very forgetful. But at what point, when is he not qualified to redo his will and not have it challenged?
Sure. That's an important question to assess, because it is a legal determination and not necessarily a medical determination. At the time that an individual signs a legal document, the law says that they have to understand the nature and extent of what they're signing. So in other words, it's really, really easy to tell the extremes. And for example, Donna, I've never spoken to you before, but I can already tell 5 seconds into your speaking that you would clearly be legally competent to sign a document. it is also very clear when somebody's clearly legally not competent. There's a lot of gray area in there, and sometimes we have had to make the signing day on a day when a person was having a good day. Because sometimes when people have cognitive impairments, they have good days and bad days, and you have sundowners, and you have different types of the times of the day. So it can become a legal question. Typically, if somebody is at a point in their progression where they can understand and answer the questions that we ask them when we're drafting a will, then we fully anticipate they will be okay to do that. So the key is at the moment that they sign it, when you sign a will in Texas, you have a notary, you have an attorney, you have two witnesses who are there to make that assessment. And it usually is pretty clear. I can tell you that the times when it hasn't been, we have on rare occasion had to have somebody come back on a different day and see if they were having a little bit easier time. You definitely cannot process and have somebody sign a will if they clearly don't understand what they're signing. Did that,
right. And I agree. Yeah, that answers. I know what you're saying. You're very right in that there's good days and bad days. Someone even suggested that it be videotaped to help clarify that they're there, they're alert, and answering the questions. Is that a recommendation, or is that just an extra thing?
Well, I can tell you, I've been practicing law 17 years. I've never videotaped a will signing. We put with the witnesses, we have a series of questions that we ask the individual who's signing. It's called a testator, the testator, in front of the witnesses, and then the witnesses sign off. Those questions were answered to their satisfaction, and we've never had a problem with it. I think that the video the video will is something a little bit more in the movies, but I mean, if somebody insisted upon it, there's nothing wrong with it.
Yeah.
But no, we don't do it as a matter of course, no.
Okay, perfect. Thank you.
Does anyone have any other questions?
I have one more if nobody else does.
Yeah, go ahead.
Sorry, I'm not trying to hog. My husband and I have been married for about 30 years. The property that we have, it's a home with 15 acres, and it was in his name as sole owner before we married. We do have a will that is a transfer on death, but it has been suggested that my name should even be on that will, on the deed, that we could go ahead and modify the deed and place both of our names on it in addition to the transfer on death. And I did not know if that was a second layer of protection for myself, or because he has 2 children from a previous marriage and I have 1. So we're just trying to make sure, because he does want it to transfer to me, and then I'm to establish if I'm whatever needs to be done after he's gone.
Okay. So I'm gonna, you confused me a little bit with your question, because you said that he has a will that is a transfer on death. And I want to be sure if you're saying that he put a transfer on death deed in place and filed it with the county clerk, or are you saying that in his will he says that upon his death it should transfer to you?
Yes, sir. That's the way. That's it. And it has not been put at the courthouse. It's only with an attorney's office.
Okay. All right. Yeah. Typically, most people don't file a will with the court prior to someone's death. You technically can record it, but most people don't. So a specific question like that is probably best addressed in privacy, attorney-client privilege and that type of thing. And so I always have to be very careful. I can answer general type questions, but I always want to avoid specific legal advice to somebody when we haven't been able to sit down and look at documents and do all that. But for the purpose of kind of the general answer, that is definitely a question that comes up a lot, is how do I, upon my death, transfer this to who I want and make sure that who I don't want doesn't get it. And if the person I want to get it is not still living, I want to be sure that it transfers to the next person of my choice. And we sit down and go through all of that with you. That's a very common thing to look at and make sure that we have right.
Okay. And that was it. I'm just kind of getting a general idea, not to be specific to my case right now.
Does anyone else have any questions? I literally hear like birds chirping.
Well, it's better than crickets, right?
Right?
Ask a question of a crowd, you don't like crickets.
Well, I'm sitting outside, so I don't know what you're hearing from my side. So there's cats and dogs and birds. Shannon, so sorry.
Okay, Shannon, I know that you said that you would have somewhere our contact information for everybody. I want to be sure that they get that just in case. If you need to reach us, I can give you two numbers that where you can reach us. Our main office number, and this would be if you were ready to come in, sit down with us, make an appointment, or even schedule a phone conference or whatever is necessary. Our main office number, it's a 512 area code, and our main office number is 336-1529. It's 336-1529. Yeah, there you go. And VeeCee, you would think that I would know your number by heart, but I just hit a button on my phone and it dials. VeeCee, I know, answers her phone after hours. And I don't want to put you on the spot there, but I just happen to know that you do.
I do.
So
I certainly do.
If you also want to give your number there.
Okay. Yes, I'll be glad to answer your questions. I know sometimes things happen on the weekends or holidays, and if I've got my phone with me, typically I will take your call. My number is 512-229-6561, and if I'm not able to answer, be sure and leave me a message, and I'll be glad to get back with you as soon as possible.
Perfect. And I will also include those on the email that I send back to everybody when you receive the recorded presentation. It's on the group chat. So if you want to go back and look on the group chat, you can see those numbers on there. But I'll also send you, and you'll have VeeCee's email is also included.
Yes.
Where I email the recording. So you'll have her email as well, and the website to the Barnett and Leuty law firm. Again, I thank you all for answering, and these questions have been wonderful. They've been great. They've helped me out personally too. So I hope that everybody was able to get the information that they were seeking, a little bit more knowledgeable than we started about 2 o'clock, right? So I appreciate that for everybody in joining us. If no one has any other questions, we will end our call for today. And the VA will be joining us next week. So if you have any questions regarding the VA and the support services that they offer, joining us for that call next week. Thank you, everybody, and you have a great week. Thank you.
Thank you. Thank you.
Bye-bye.
Bye. Thank you.